Yes, Mr. Drake.
Thank you, my Lord. In relation to the outstanding question as to whether the versions of the rules are the same, I'm told that they are. I haven't independently checked that, but I'm told that they are. Right. Can I pick up on my learned friend's submissions really in relation to the scheme and logistics? And it was said by my learned friend that this court should take very little from the geolistics decisions. We, of course, differ, and we suggest that there's a lesson to be learned. It was said in the first place that it was a very different scheme. Now, we said that's simply not right. That when one looks at the two schemes, it is plain as a pikestaff that the two schemes are concerned with the very same purpose, that is the protection of policyholders in circumstances where an insurer may fail. The two schemes were administered by the same body, FSCS, having administered the 1975 scheme as the successor, and as the administrator of the current scheme from the get-go. And of course, in each scheme, the rules use the term "in respect of" to define what is and what is not compensable. And of course, it leads us to the submission that if the PRA wanted to use the words "in respect of" to carry a different meaning than that ascribed to them with respect to the earlier scheme, as determined by this court, so as to mean something else, so as to mean for or for payment of, then with the greatest respect, all they had to do was say so. Now, my learned friend made some submissions in relation to the defence costs under the prior scheme for geologistics. And as was submitted in the court below, it was said that the fact that they were covered by the policy there made all the difference. Now, I'll find the reference in the judgment where the learned judge described that analysis as flawed, but again, with respect, we would adopt what the judge said about that. That analysis is flawed. The fact that the defence costs were covered was a factor to be taken into account, but it certainly wasn't determinative of the question of the proper construction of "in respect of." And that's obvious on a careful reading of both the decision before Mr. Justice Davis and the decision of the Court of Appeal. If I can put it a different way, the fact that, perhaps if we just turn up geologistics so that we can have the sections in front of us. So tab 2 of the authorities manual. And if we go to page 57 of the bundle, we'll see there sections 4, subsections 4 and 5 of section 6, just turning back the page to orient yourself. Section 6 is compulsory insurance policies and securities. This section applies to any policy which satisfy the requirements of, and then there's a reference at B to the Employers' Liability Compulsory Insurance Act 1969. And then the particular subsections are at issue in those cases are 4 and 5. The way to understand it, the fact that the defence costs were covered under the policy was a necessary precondition, if I can put it that to be covered by subsection 4. But once that was established, it then became a question under subsection 5 of whether such costs were in respect of the liability subject to compulsory insurance. Now, as to that question, the fact that the defence costs were also covered by the composite policy was not material. We've moved on, the court's moved on to a different question. The question for both courts was what was the relation of those defence costs to the, if I can use a shortcut, to the compulsory liability. Section 6.5, providing that liabilities in respect of compulsory liability were compensable. And it was for that purpose that in respect of was construed in those decisions as meaning in connection with. So that's a bad point.
But your case involves saying that the scheme has been changed since then. Under these provisions, it was, as you put it, a precondition that the claim was for something that was covered by the insurance. You say that, not say the present scheme. It covers things, claims that are not claims under the policy. So the scheme has changed, you say.
The scheme has. I'm not suggesting that.
By using the same language in respect of,
yes.
You say that indicates that there was an intention to change the scheme from one under which, under the 1975 Act, only covered insured claims.
No, I'm not making
to one
that.
which, well, but that is the effect of your submission, isn't it?
I don't believe so, but I may be missing your point.
It's my fault. The point you were making under 6.4 is that it was necessary to come under this scheme, that the claim for costs in that case was an insured risk. Yeah. You say that the scheme in its present form...
Sorry, if I may interrupt, my Lord, my apologies. Subject to the requirements of subsection 5.
Yes. Yes, which in this case didn't prevent it.
Yes.
But the present scheme, you say, is not confined to insured losses. So it's wider than the previous scheme.
Yes, my Lord, I am saying that.
And it's achieved that, you say, by using the expression in respect of, which previously didn't have anything to do with whether they were or weren't insured losses. What's the logic of that?
The logic of that, my Lord, is that the scheme with which we are now concerned is designed by the very use of its language to cover matters that are beyond the insurance indemnity.
That's what you're seeking to prove, yes?
Yes.
But how do you get that out of geologistics, is the point I'm putting to you.
We get that out of geologistics by dint of the definition that was given to the term in respect of in geologistics. I accept that they were applying different statutory rules in relation to an earlier scheme. I accept that.
But it was given in a very different context, as my Lord pointed out. The words in respect of were used to define the extent of a carve-out from what was otherwise protected. So if it's under the policy, prima facie it's covered. But then there is a caveat to that, and it's only if it's in respect of a liability that's a compulsory liability, then you're actually covered. So you look at the narrower scope. So in respect of there is given a fairly wide ambit to make sure that claims under the policy are covered in order to give 100% coverage for the claimant. Here we're dealing with a very different use of the term in respect of, which is being used partly in the definition of protected claim and partly in respect of what you may claim under the fund. And logically it's got to mean the same in both contexts, I would suggest. But where do we actually get any help from geologistics on that?
Well, my lady, I don't think I can say anything else than what I've said, which is to say that the court before Mr. Justice Davis and the Court of Appeal were concerned with the phrase in respect, albeit in a different context. But they ascribed to it a certain meaning. And they ascribed to it a certain meaning in connection with, in order to understand whether certain elements of a claim which were not compulsorily insured, or were not required to be compulsorily insured, were also covered by the scheme. We say the parallel here is that the principal purpose, as I said earlier, in relation to the current scheme, is the protection of the insurance indemnity. But it is not limited to that. And the reason it's not limited to that is by use of the term in respect of. And had the PRA wanted to come up with a different formula, we would have seen it.
Thank you.
The second point that my learned friend made in relation to the limited value, he said, of geologistics was the concession. Now, it is right to say, of course, that Mr. Justice Davis did have regard to a concession, and that it was addressed at some length, and the court can pick it up at paragraph 34 on page 63 for reference. But what's important to understand is that Mr. Justice Davis considered that the concession was rightly made, such that we say the result would have been precisely the same, the effect of Mr. Justice Davis' observation is that the result would have been precisely the same absent the concession. And at 45, we suggest that is made clear. Paragraph 45, Mr. Justice Davis says, I would like expressly to state, in view of the significance given in the arguments to the concession by the scheme, that it is liable for a successful third party's claimant's costs. That in my view such concession was rightly made by the scheme. It was rightly made, in my view, in essence precisely because it acknowledges, at least to some extent, the potential reach of the phrase in respect of, as used in subsection 5. That's before Mr. Justice Davis. Now, in the Court of Appeal, the concession gets rather more short shrift. In the Court of Appeal, Sir Sidney Kentridge argues that the concession has no bearing on the question of whether defence costs were caught by the phrase in respect of. Now, if we look at paragraph 12, for example, this is behind tab 3. It was argued, picking up in the middle of the paragraph, it is to be construed as not encompassing any liability other than an established liability of a policyholder, which he is obliged to have compulsorily insured. Now, in seeking to promote that narrow construction, Sir Sidney Kentridge was seeking, in effect, to walk around the concession. But in any event...
He was trying to abandon it, wasn't he?
Well, not quite, because he sought to, paragraph 20 addresses how he seeks to make concession consistent with that submission.
Yes. Yes, I accept. but it didn't play in any part of the decision by Lord Justice Waller. And one can see that by looking at, for example, going to paragraph 23. In any event, it seems that the narrow construction placed on section 6.5 of Sir Sidney is inconsistent with there being two subsections. And going to the bottom of that, at G, what is contemplated is therefore that under a policy which is required to be taken out, the policyholder will be entitled to recover against the insurance company some indemnity beyond that for which statute compels insurance. But by virtue of section 6.5, that right to indemnity must still be in respect of the liability subject to compulsory insurance. And he picks it up at 25. And if I can just ask, insofar as the court hasn't, if I just ask the court to read from 25 through to 29, you get the sense of there what Lord Justice Waller was saying.
We've looked at this. Can I put something to you and see if you agree with it? There seem to me, on my part, to be two elements to Lord Justice Waller's essential reasoning. The first is in paragraph 23, which is essentially, if Sir Sidney's main submission were right, you wouldn't have needed to split it into two sub-paragraphs. That's got nothing to do with the expression in respect of, as such. That's the structure of the two sections. His second point is the one that he addresses in paragraph 25 in relation to claimant's costs and then applies over the following paragraphs to defendant's costs. And it is that the words liability subject to compulsory insurance, I'm reading 3 lines up, are descriptive of a type of liability covered by the policy and not intended to describe an actual established liability.
Yes, meeting Sir Sidney Kentridge's argument that it had to be an established.
Exactly, and therefore, if that's what you're talking about, in respect of, obviously means in connection with. Now, neither of those are really starting with the words in connection with and treating them as bearing prima facie even the meaning in connection with. They're two particular meanings on the other language and the way in which it was framed by way of the scheme of the submissions in that particular act. Is that a fair way of looking at the ratio for at least the Court of Appeal decision?
It is, my lord. Yes.
Thank you. Thank you.
Well, picking up, and my lady, picking up point in relation to 17.2. Now, as I understood my learned friend, it was said that if defence costs were incurred alongside a liability that was compulsorily insured, I think I have this right, then under 17.2, the claim for defence costs, according to my note, would not be in respect of a liability subject to compulsory insurance, but would be caught by 17(1)(b). In all other cases, the level of cover is 90%. We say our first submission in relation to that is that that's odd as a matter of construction. The second submission is that we see the wording in respect of a liability subject to compulsory insurance is precisely the same wording that appeared in geologistics, and yet the scheme argues that defence costs would not be caught by in respect of a liability subject to compulsory insurance, but would be caught by all other cases, which we say is also odd. And we also say the result is rather odd, that one would achieve 100% cover in relation to the liability subject to compulsory insurance, but 90% of those costs.
I mean, just interjecting there, thinking about it further, I wonder if it's even 90%, because for anything other than at least a small business, as I understand it, the scheme wouldn't apply other than in respect of compulsory insurance.
Yes.
In other words, for any large business, they're generally not eligible claimants, as I understand the scheme.
That is correct.
There is a carve-out for that in 8.4. Which has similar language in respect to the liability subject to compulsory insurance.
Yeah. Yes, my lady, with respect, I think that's right.
If that is right, then on the face of it, the only way you get those costs is if they fell within little 1, and the words in respect of were given the same meaning as they were in geologistics.
Yes.
Assuming that the costs in question are the subject matter of the policy.
That was certainly a requirement in the earlier scheme.
Yes, 17.2(1)(a) appears to use the defined term claim.
Yes.
So the claim on the insurer is in respect of a liability subject to compulsory insurance. You can see how that fits in with geologistics.
Yes.
There's a claim on the insurer under the policy, which is in respect of a liability subject to compulsory insurance.
Yes, my lady.
And you would say, well, if in respect of, in this particular part of the rules means the same as it does in geologistics, then why should it mean any different in the other parts of the rules?
Precisely so. Can I do fairly swiftly with the points that are made against us in relation to rules 17, 19 and 20. In relation to 17, we set these out in our skeleton, if I can give you the reference. 45 as the first consideration of it. Just looking back at 17. It is relied upon, of course, for the submission that in respect of where it's used in this rule means something other than in connection with. And as an overarching solution, we say that reading it as for payment of doesn't make obvious sense, as is the submission. As to the learned judge's view of Rule 17, the reference is at page 143 of paragraph 120. Where the judge said that in relation to this rule, the fact that wider claims beyond those arising under the contract of insurance are not explicitly mentioned in the rule misses the point. The scheme suggesting that because the rule refers only to protected claims, then no other claims are intended to be compensated by the scheme. As they put it, such other claims that may be connected with the protected claims, in their words, were not intended to exist. The judge dealt with that in the way that he did, by saying that the fact that wider claims beyond those arising under the contract of insurance are not explicitly dealt with by Rule 17 misses the point, and that one always needs to go back to the definition of 3.1 qualifying conditions and the definition of claim as incorporated in Rule 3.1. Now that, with respect, is something with which we agree. We say that the rule is concerned explicitly with sums to be paid for protected claims. We say that it doesn't apply to compensation that is not protected claim, not a protected claim, but is in respect of a protected claim. We say that makes perfect sense in the context of the policy, because the paradigm case is the case that we were talking about earlier, which is that an insurer fails and the FSCS steps in and provides cover for the insureds. What it doesn't do, what it doesn't grapple with under this rule is where the insurer fails and in the context of which the insured has been put to the time, trouble and expense of prosecuting the insured's rights against the failing insurer before the collapse of the insurer. So what this is concerned with is, under 17, the contractual indemnity under the policy. It is not concerned with, and doesn't address, where elements are compensable beyond the contractual insurance indemnity.
Assuming that's right at the moment, that it's confined subject matter, isn't it rather strange that if you're correct and there are other types of financial compensation that are covered by the scheme, that nowhere else in any of these rules do we find anything similar relating to those, because we've got very, very detailed rules about the protected claims and how much they can, how much you can recover, and the accumulation of protected claims under 19, and so on and so forth. And the only mention of these other claims, according to you, is in the definition section.
The only mention of the other claims, according to us, is in the definition of the qualifying conditions and the definition of claim.
Yeah.
But
so no financial limits, and subject to the word valid, no other sort of limit on what you could actually recover.
That is what the definition of claim provides for, and that is what the qualifying conditions provide for. Now, if the FSCS wanted to limit the recovery of those matters, they could have expressly said so throughout the rules, that the compensation is limited to the contractual insurance indemnity. Nowhere is that said. Rules 19 and 20 these are at page 215 and 216 of the bundle. And again, what is said against us here by the scheme is that by limiting the amount payable in respect of a protected claim to the sum of protected claims, shows that in respect of means the payment. That's the submission. And that when the same phrase is used in Rule 3, it means the same thing. Now the judge at paragraph 121 for the court's note took the view that this rule was concerned with the quantification of the overall protected claim, but does not speak to the overall claim as defined by Rule 3.1. So it's the same point again. And with that, we agree as well.
I'm not sure that fits, not with the language, because isn't the language, let's just go back to clause 3.1. Clause 3.1, as I recall, it is concerned with a claim in respect of a protected claim, isn't it?
Yes, my lady?
Yeah, a claim is made in respect of a protected claim. So you see exactly the same language, a claim in respect of a protected claim in 19.1, and 19.3 limits that to the sum of the protected claims. Well, that makes absolutely no sense to me, if you're right, because it means that the cap on it, which is the quantified by the amount you can get under the policy, excludes anything outside the policy. Or do you say in respect of means something completely different in 19.1?
My lady, we do say that the use of the phrase in 19.1 is to be read in this way. So if I can address these in series. We say that the judge's view at 121 that this is concerned with the quantification of the overall claim, overall protected claim, and doesn't speak to the overall claim in 3.1 is right. We say so for these reasons, and I hope to answer your question. The first is that comports with the use throughout the rules of the phrase in respect of. There are various rules, and I can give them to the court for their note. In addition to 3.1, there are 8.1, 8.2, 8.10, 12.1, 12.2, 18.7. All where we say the natural and ordinary meaning of those words means in connection.
Sorry, I think I'm missing something now. In 19.1, the amount of compensation payable to the claimant in respect of a protected claim is the amount of the overall net claim. And 19.3 tells you that that is the sum of the protected claims.
Yeah.
Isn't that suggesting a narrow meaning for in respect of?
We say that what it's suggesting is it's just dealing with protected claims. It's not dealing with anything beyond protected claims.
Yeah, but then you're having to read in respect of there as
four.
equal to 4.
We say at 19.3 it should be read as the sum of the protected claims, in order to make sense of it, should take its meaning from the rules as a whole, as we say.
Which is the particular provision upon which you rely as imposing the payment obligation in relation to your client's claim?
The payment obligation is set forth in 3.1.
No, that's a may. That doesn't impose an obligation of itself. You've got to find an obligation to pay. At 16, you've got one which is dealing with timing, but it's only in 19 and 20, is it, that we find the relevant obligations
Yes.
that make payment.
Yes.
Which of the provisions in 19 or 20 do you say contains the obligation to pay your client's claim?
We say 19.6 says the FSCS must calculate the amount of compensation due to the claimant as soon as reasonably possible after it is satisfied the conditions in 3.1 have been met.
But that's just
Yes.
telling it to do the maths. isn't
That's
it?
timing. And I think 16 says the same. Says you must pay as soon as you've done that. Sorry, it doesn't say the same. It says then when you've done that, that's the second half. It must satisfy itself that the conditions in 3.1 are met if they're met. You must calculate the amount of compensation, and then 16 says you must pay within 3 months, 6 months.
Okay.
But they,
Might you say it's a combination of 16.1 and 19.6?
but 16.1 is dealing with timing, isn't it?
Yeah, and it's paying a claim.
It's not just
defined
time.
term.
Well, it's headed time limits on payments and postponing payment.
Yeah.
The conditions are satisfied that the conditions in 3.1 have been met, and it's calculated the amount of compensation due to the claimant. Brackets, that must mean done the calculation in accordance with 19, isn't it?
I think it's the only place you find the obligation to pay payment is 16.1
Well,
because
Well, it's 20.2. 20.2 is where actually
Yes.
the payment obligation is in relation to the kind of contracts
Yes.
that we're talking about. But that doesn't help you because that makes clear that the calculation is the amount due under the contract and the obligation is to pay that amount,
Yes.
which is why I asked you where else you find the payment obligation.
Well, I can't improve on 16.1. I accept that it's headed time limits on payment. But
Well, but it also says must pay a claim, and it appears to use it in the defined sense
yeah.
of claim.
So we would rely on 16.1 as providing a payment obligation within the period of time that's stipulated in 16.1 to pay the claim as defined as met by 3.1. Now, the other thing to recall is that these objections on behalf of the scheme in relation to 17 and 19 don't bite in relation to the second way that we put our case.
No.
The second way that we put our case is that our claim is for a protected claim.
does that help you with 20.2?
No, not with 20.2, sorry. Certainly in relation to 17, and certainly in relation to 19, which are speaking of the compensation payable in relation to a protected claim. I accept that 20.2 is narrower and speaks of the calculation simply in relation to the insurance indemnity. If we're right about the definition of protected claim, which is the definition that I took the court to earlier, then 17 and 19 don't touch the manner in which that is put. 20.2.
But you've still got to get your payment obligation out of Rule 16.
Yes. Now, one observation as well in relation to the breadth or narrowness of what's compensable under the scheme, we say is informed by looking at Rules 12 and 13. Rule 12 is on page 210, as is Rule 13. And these rules provide for assignment and subrogation. I don't want to overstate this point, but we say it's important to bear these in mind when you're construing the breadth of the compensation that's payable under the scheme. And the reason we say it's important is because there is a wide, universal right of assignment, likewise of subrogation, which we say is inconsistent with the notion that all the FSCS are doing are paying out in respect of an insurance indemnity. So we see at 12.1, the FSCS must, or if it is subrogated automatically to the eligible claimant's rights, may make a payment of compensation to a claimant in respect of a protected claim, conditional on the claimant assigning the whole or any part of his rights against the relevant person or against any third party, or both. And we see the same language in 13.2, so all of the claimant's rights against the relevant person will be deemed to be automatically assigned. By
Sorry, where are you now?
Sorry, in 12.2.
12.2, right.
So upon payment of the compensation by the FSCS to an eligible claimant in respect of a protected claim, all of that claimant's rights against the relevant person, the insurer, and any third party involved will be deemed to be automatically assigned by way of legal assignment to the FSCS, absolutely on terms published by the FSCS. Now, the question that we pose rhetorically is, why are they taking such a broad assignment of all rights enjoyed by the insured? Likewise, why are they being subrogated in respect of all rights enjoyed by the insured, if all that their scheme does is set up compensation for solely and no more the contractual insurance indemnity? Now, it's not enough, as was said below, to say that, well, if we take more than that on the assignment or the subrogation, we'll just pay it back. Of course they would have to, but that's not the point. The point is that here, the breadth of the assignment and the subrogation suggests something greater is intended to be compensated over and above the contractual indemnity under the insurance policy.
So are you saying that here, having paid because an element was paid, wasn't it? VAT?
VAT was paid.
Are you saying that engaged the automatic assignment
Yes.
of the rights that we're talking about?
Yes, and I actually don't know about that. I haven't been instructed as to precisely what happened by way of the assignment or the nature of the assignment. But
But
it's,
the subrogation is automatic as well, isn't it?
Well, certainly the assignment, there's a deed assignment.
Because it's deemed automatically under 12.2.
yeah,
All of the rights against the insurer, for what they're worth, automatically assigned.
yes, and by way of legal assignment to the FSCS in 12.2, absolutely on terms published by the FSCS.
And there's subrogation is in 13. Well, that's permissive. Subrogation.
There is a power to reassign if they're not going to pursue it in 12.8.
And of course, 12.7, while I'm reading it, if the claimant assigns the whole or any part of his rights against any person to the FSCS, in accordance with this chapter, the effect of this is that any sum payable in relation to the rights so assigned will become payable to the FSCS, not the claimant. It seems to us that there's no sensible answer. Certainly we have received none in relation to that. And as I said, the answer provided in the court below was that, well, if we get more than we take, we'll repay.
Well, let's take it in stages. 12.1 is in relation to situations where FSCS is automatically subrogated to claimant's rights. And
My lord, is that right?
no, sorry, no. You're quite right. It's not. It's may, quite right. It's may in cases of subrogation. So that talks about
Making payment conditional.
making payment conditional.
So if the
Let
parent-
me start again. Let's take a case in which we are dealing with subrogated rights. What the FSCS may do is require an assignment of, quotes, the whole or any part of his rights against the relevant person. But one would, in a purposive way, think what's being referred to are the subrogated rights in relation to subrogation. It can't mean you can require an assignment of all rights, which wouldn't be rights
That's what it
to
says.
which you're subrogated. So that doesn't provide for a width of assignment or subrogation, which tells one anything very much about what the protected claims are.
But with respect, my lord, only if it's read in the way that your lordship.
Well, but I thought you were accepting that it was. No.
No, I'm not.
12.2 is
I'm not suggesting.
12.2 is very wide. I
But
mean,
12
suppose that the insurer, the insolvent insurer, has a parent company guarantee. Then under 12.2, the FSCS could, I think you would accept, could find itself with an assignment of any claim that the assured might have had against the parent guarantor.
Well, I wonder whether the expression involved in or connected to the claim in 12.2 governs the third party, not the relevant person. It still says all of that claimant's rights against the relevant person. But it might mean
Rights
and
against
all of
the
the
person
claimant's
and
rights against the third party who's involved in or connected with the claim.
That's certainly the way I was reading it.
Yes. So we're dealing with all of the claimant's rights and seeing whether that is to be construed as wider than the rights to which they would naturally be subrogated upon payment of the compensation. And it might be that one would read that as meaning all of that claimant's rights in relation to the protected claim.
It doesn't say that.
Well, it says upon payment of compensation in respect of a protected claim, all the claimant's rights shall be deemed automatically assigned. And I don't think it would be an odd way of construing that as meaning all rights in relation to the protected claim. Suppose you had a completely unrelated claim against the same insurer.
Could be an employee of the failed insurer.
Well, you might just happen to have another policy on which you had a different claim. Can't mean any claims of any kind you happen to have against that particular insurer, can
No,
it?
I would accept that.
So it must be linked to the protected claim in some way.
Linked by the words in respect of.
Well, the words in respect of aren't there.
Yes, they are.
Not-
Claim it in
not in-
respect of a protected claim.
They're in 12.1, not in 12.2.
Well, that's identifying what's paid. So that just takes
Yes.
you back to the debate we're having as to whether it's a protected. Let me try and find a neutral expression. Whether it's a sum of money to which you're entitled under the scheme. That's the prior question, and that's what's we've got to decide what's meant by that when it talks about making a payment in respect of a protected claim. But if that payment has been made, the premise, I think, of your submission, I'm sorry to be so slow trying to catch up with it, is that 12.1 and 12.2 provide for subrogation or mandatory assignment of a wider class of claim,
Universal.
universal rights. And I'm wondering whether that really can be true as a matter of construction of 12.1 and 12.2.
We would suggest
It would be a surprising result, would it not?
Well, it would be a surprising result if they're right about the narrow basis.
No, on either basis, wouldn't it? Because you haven't even got the same wording here, have you? You've got involved in or connected to the claim, or you've got all the claimant's rights. You're not for these purposes construing the scope of the wider scope of the assignment by reference to the words in respect of, are you? That's just what you've been using to define the payment, and that goes back to the question we've been deciding.
On the face of it, it's got no qualification at all. On all of their rights against the relevant person or its successor, and all of the claimant's rights against any third party involved in or connected to the claim.
I think 12.2 may. Let's put one with it. 12.2 does give you.
Be wide enough to cover a different claim under the same insurance, which wasn't a protected claim.
Sorry, my lady, but, sorry. 12.2 says upon payment of compensation by the FSCS to an eligible claimant in respect of a protected claim. That's
Suppose they've got a
Right,
claim
so-
against the same insurer under a completely unrelated contract of insurance, which doesn't happen to be protected by the scheme.
No, my lady, if I may, all of the claimant's rights against the relevant person and any third party involved in or connected to the claim. Sorry, we're back to where we were before. My apologies.
Yeah.
I mean, you don't qualify the scope of the automatic assignment in 12.2 by reference to the words in respect of. That's just your rubric. You could substitute for that upon payment of of compensation for something covered under the scheme.
But what is curious is that there doesn't seem to be any, unless you read words into it or unless you look at the words involved in or connected to the claim as also inhibiting the rights against the relevant person. I suppose you'd have to say that the claimant's contractual rights under the contract of insurance against the relevant person.
Well, I imagine you said it's all the claimant's rights, which we've just been talking about,
Yes.
in relation to the payment, i.e.
Yes.
all the claimant's rights in respect of a protected claim, and it just takes you back to the same question.
13.7.
Right. So is there anything more you want to say about 12.1 and 12.2?
Well, sorry, we're still in
13.7.
13. It's still, no, sorry, we're on the same topic. I'm trying
All right, sorry.
to rummage, to try and find some assistance for the court.
Right.
13.7.1 looks like it says something that shall immediately and automatically be subrogated, subject to conditions, to all or any part as determined by the rights and claims in the UK and elsewhere claimed against the relevant person.
Gosh.
With it.
Legal, equitable, or
Then it
anything
In
else?
respect
goes on.
arising out of a claim in respect of which the determinant.
So that has in respect.
Well, that's really wide, isn't it?
Yeah.
That doesn't seem to me to chime with it being a claim under the contract of insurance.
Well, I wonder whether that's lawful. The FSCS can be the determinant of its own rights of subrogation of that kind of width.
Mm.
But anyway, that's. But yeah, but thank you for drawing that to our attention.
Grounds 2 and 3 I can take rather quickly. Ground 2, I've articulated the basis of it by taking the court to the definition of protected claim. That was some time ago, but...
Yes, you're looking quizzically at me. I hadn't forgotten, yes.
So if I can just take you through these steps quickly then. This is paragraph 52 of our skeleton, which is behind tab 7 of the hearing bundle. Page 67 of the bundle is the reference. It sets out there the definition of protected claim. And picking up on that definition rather than trawl through it again, just let me go through the steps that we say follow from that. The steps are these. East-West owed a civil liability to provide insurance under the policy. First step. The civil liability was plainly owed under the policy. The claim made by the respondents for their unpaid legal costs and interest is a valid claim in respect of or in connection with that civil liability. The respondent's application therefore meets the qualifying conditions in 3.1, and we're back in the territory of what does in respect of mean in those circumstances, which we've traversed.
On the judge's findings, it means something different from what he held it meant in 3.12.
Yes, the judgment is paragraph 127 of the judgment. The learned judge, with respect, simply collapsed the definition of protected claim to mean a protected claim is a claim under a contract of insurance without considering the iterative steps of including the definition of claim within the definition of protected claim.
Although curiously, he had considered those when he was purporting to address the Rule 3.1 question on
Yes, I think
round
that's
1.
right. So, in our respectful submission, he erred in that respect, and the respondent's claims are, in and of themselves, a protected claim on that basis. And all that requires is a careful reconstruction of the definition of protected claim. And the third way we put the claim is rather higher than that. We say the claims for costs and insurance are claims under a contract of insurance. And we say that for the reasons that we set forth in our skeleton, which the court will be alive to, which is the relevant distinction here is between contracts of insurance as a regulated activity and unregulated activities. And that's the right way to think about it. And so that these costs and these interests do arise under a contract of insurance in the sense that they arise with respect to a regulated activity. So if I can just flesh those out, we submit that the liability owed under a contract of insurance means that that is the source of the liability and not some other different non-insurance. That's the divide, that's the distinction. Non-regulated activity. This distinction is one that was recognised in geologistics itself. If I can take the court to paragraph 17 of the decision at first instance, behind tab 2. And when speaking, we can pick it up there at paragraph 17, when Mr. Justice Davis there was speaking about the policy behind the 1975 Act, and of course equally true of the current scheme, is to provide a degree of financial protection to those policyholders exposed by the collapse of insurance companies, which are after all meant to be authorised and regulated. And we say it's not the right approach, as the scheme would have it, to limit the insurer's liability for insurance indemnity, but rather it's broader than that. And we refer as well to section 213 of the Act, which is behind tab 11. At page 183 of the bundle, at subsection 3. The compensation scheme must, in particular, provide for the scheme manager to assess and pay compensation, in accordance with the scheme, of course, to claimants in respect of claims made in connection with a regulated activity carried on by the relevant persons. So that's a distinction recognised by the Act itself. And that's where we say FSMA draws the line between claims made in connection with the effecting or carrying out of a contract of insurance, as opposed to claims made which are not in connection with the carrying out or effecting of a contract of insurance. And if it's understood on that basis, then we say it follows that the claims for costs and interest are claims under the contract of insurance, as that term is used in the scheme. Those are my submissions.
Can I just raise two questions that are in my mind? The first relates to protected claim. We know what 9.1 says, but just standing back for a moment, if you, as a layman, were to think, what's protected claim likely to mean, you would think it means a claim which is protected by the scheme, i.e. one that's going to enable you to recover under the scheme. And indeed, that is what is said in terms in the glossary about protected claim. It means a claim which is covered by the policyholder protection scheme, as defined in BPR 9.1. But the effect of the judge's decision and your case is that the scheme covers claims which are wider than that description, i.e. wider than claims covered by the scheme. Surely some mistake.
Not if the rules so provide, is the short answer. And the rules do so provide, because they do definitionally provide.
So that the glossary is wrong, essentially, in saying that a protected claim is a claim which is covered by the policyholder protection scheme as defined in policyholder protection 9.1. Because you say 3.1 extends it to other claims.
Because 3.1 and the definition section of the rules themselves extend it to other claims. I mean, that is a natural consequence of simply inserting the definitions used by the scheme in the definitions themselves.
Yeah, or to put it another way, when it says protected claim means a claim which is covered by the policyholder protection scheme as defined, it means it includes a claim, or is one of the claims which is covered by the, sorry, not includes a claim, it's one of the claims which is covered by the policyholder protection scheme.
Well, my lord, we would say that it is, in the way that we put it, it is covered by the policy.
Yes, but it's only one of the claims. It's not. It isn't identifying the claims which are covered by the policyholder protection scheme. It's simply one of a wider class.
Well, it's perhaps, if you will, it's the central claim is a protected claim, but I'm not sure that takes any further either.
Thank you. And then the other arose out of the 2020 document, which foreshadowed the change for building guarantee insurances, which we've got behind tab 18. Mr. Handyside relied in particular on 1.3 and 1.4 as indicating that at least the PRA thought that the benefits that they were talking about bringing in were benefits under the contract of insurance rather than anything wider. Now, the way he put it was only, well, that's consistent with his construction of the way the rules work. So that he wasn't seeking to place any positive reliance on this as supporting his case. But I was wondering, when you were making your submissions as to how this is to be treated as secondary litigation, which differed from his, whether this is something that is an aid to construction of the rules themselves. In secondary legislation, usually now, one gets explanatory notes at the end of a statutory instrument and or an explanatory memorandum prepared by the department under the Secretary of State who's promulgated the instrument. And it's well established that those are legitimate aids to construction, although they may have greater or lesser weight. And I think there's some authority that says that they may be given greater weight if they're prepared by the department which has promulgated the legislation. So it might be said of this, well, here is the equivalent. Here is the body who is making the secondary legislation, explaining what it is intended to achieve. And 1.3 and 1.4 suggests that it's intended to achieve 100% or 90% of benefits which arise under the contract of insurance, full stop. Is that a legitimate aid to construction in that way or not?
If you're asking me, I think you are,
Yeah.
whether the court is entitled to take into account this document in interpreting the rules, our answer would be yes, if that is the question. If you're asking me the next question, which is whether the language at 1.4 or 1.5.
Yes, I'm sorry, I may have said 1.3 and 1.4. 1.4 and 1.5, you're right.
Of any benefit under a contract of insurance is to be given the narrow meaning ascribed to it by the scheme, we say no. Number one, and number two, we say that it doesn't speak to.
Sorry, can I just stop you at once, see if I understood it? So you would say benefit under a contract of insurance includes claim in respect of, in the sense you're using it.
Yes, thinking about it this way, if it said that the costs and interest are not compensated, then the immediate effect of that is that my clients are not entitled to any benefit or every benefit of the contractual indemnity, because they have, if their contractual indemnity is worth £100, they have spent £30 in acquiring that contractual indemnity. So it means that their contractual indemnity has been discounted by dint of their required effort, because the insurer breached its insurance contract. So on that basis, we say...
It's part of the cost of obtaining the benefit.
Yes.
And would that apply to the costs of pursuing your claim against the FSCS?
No, that would fall under a different category.
Why doesn't that come within the same description of something which you're expending to get the benefit of the
Because that's the
contract of indemnity?
benefit under the contract of general insurance.
Well, exactly. That's the benefit under the contract, not the benefit of having the contract or the benefit of obtaining something you are entitled to under the contract.
We still say, my lord, that unless and until compensation is paid, the practical effect is that the respondents have not received every benefit under the contract.
I understand that. The logic of that is you ought to be able to recover the costs of pursuing the FSCS.
Well, we don't put it so far.
No.
Is all I can say.
And I'm not surprised you don't, but anyway, there we are. All right. I understand the submission, thank you.
Can I just ask, going back to interpretation, you didn't comment on the case that was handed up, shop direct. As my lord said, you did make some different submissions. Can I just understand what your position is, if any, on that case?
I'm not sure what my learned friend's position is in relation to shop direct. Is he saying that provides an exhaustive code in relation to the way in which secondary legislation ought to be interpreted?
No, I think he was if I've understood it, he was suggesting that summarised the approach that we should adopt, and he was saying that that decision related to rules made under FSMA. I'm not sure it's under the same provision of FSMA, but it's made under FSMA.
Well, I accept that the decision provides guidance in relation to the construction rules promulgated under FSMA. I don't accept that it provides an exhaustive code as to the way in which this court should proceed. I don't accept, and it's not clear on the face, that anything else was said to the court in shop direct, suggesting, as we have done, that the ordinary principles of statutory interpretation apply to secondary legislation and should therefore apply to the FSA handbook. And I don't suggest that Bennion and Craze are wrong at all.
Okay, so you're not doubting the applicability of what's said in shop direct. You're saying that's only a small part of the picture.
If I may, my lady, will.
Okay, thank you very much.
Thank you. Thank you. Mr. Hanson.
My lord, just on the question about the admissibility of the policy statement, if you still have to hand the shop direct case that we handed up, there is a passage in the judgment that deals with this.
Just give me a minute.
Yes. Provide another if necessary.
Have it now.
If the court would turn to paragraphs 78 to 80, there was some discussion about this, and the proposition that my lord just put to my learned friend, I think reflects the passage from Bennion, which is set out under paragraph 80.
Yes, that is what I had in mind.
Would it be convenient if I just deal with my submissions in reply very briefly first before coming on to grounds 2 and 3? Is that a convenient order of points?
Yes.
I don't have very much to say in reply. Really limited to this. My own friend's sort of laserish focus on the words in respect of, and the comparison with the decision in geologistics. Of course, you have the point, but we say that you have to construe those words in the context of the scheme of the rules as a whole, and then of course includes rules 17, 19 and 20. And neither version of his first two cases can cope with those rules. 17 and 19 contradict his ground 1, and his ground 2 cannot sit with, we say, rule 20.2. So it's no good just focusing on 3 words in respect of and seeking to ignore the wider scheme of the rules. That was what I was going to say. There's been some exchanges around assignments. None of that was set out in my own friend's skeleton, so I don't have, it's not a point we've come here to deal with, but just to summarise where we think these points take you. The first point is that one can't construe the scope of the scheme by reference to these assignment provisions. There's 2 separate questions here. The first is, what is the scope of the scheme? Those are the issues that are covered in the skeleton arguments. There may be a separate question as to what is the scope or effect of assignments which FSCS can or can't take. But any answer in relation to that point can't drive the construction of the rules with which we are concerned. Looking at the rules which have been you were taken to, rules 12.1 and 12.2, we would respectfully adopt my Lord Justice Popplewell's approach to construction of rule 12.2. This must all be tied into the protected claim, and of course we do also rely on 12.8, which is more than just a power to reassign the rights. If FSCS decides not to pursue recoveries using those rights, it has to reassign them if requested to do so by the policy holder. 13.7, the first point to note about 13.7 is that it's a may provision. There's nothing automatic about this. This would be a bespoke scenario where FSCS determines that the payment shall be on certain terms. We would draw your attention, if we're looking at 13.7 sub 1, the last but one line, the words in respect of or arising out of the claim. Those words obviously seek to narrow the scope of the assignment. We would pose the following example. Suppose a policyholder has a policy with an insurance company, and there is, I think, Andrew suggested this, there's a parent company guarantee. There's nothing surprising. If FSCS paid the protected claim and took an assignment of the policyholder's rights against the policy issuer and against the parent company, there would be nothing surprising or odd about that or inappropriate. And the policyholder would also have the protection of 14.4, because 14.4 provides that where FSCS makes greater recoveries through the rights than the amounts that it's paid out, then it has to pay the balance back to the policyholder. So there's nothing on the face of it necessarily alarming about 13.7. And as I've said, there's nothing automatic about it. It's a discretion. FSCS may. And no doubt, if FSCS sought to use that power in a manner which could be characterised as arbitrary or capricious, then there would again be a challenge. So it cannot be, it can't be suggested that there is some completely unfettered right to do whatever it wants, irrespective of the ordinary legal principles that apply to public bodies. That's all I wanted to say or propose to say in relation to the assignment provisions. Can I now make my submissions in relation to ground 2? Many of these points will be familiar. by their alternative ground 2, the respondents contend that their claims for statutory interest and court order litigation costs are each a protected claim. So here they're saying these are protected claims. Not that they are in respect of, but they are protected claims. PPR 9.1 defines a protected claim as a claim under a protected contract of insurance. Claim, as we know, is defined as a valid claim in respect of a civil liability owed by a relevant person under a contract of insurance. The claimant's argument, the respondent's argument here, is that in respect of, in that definition, is to be construed to mean in connection with. Their next step in their argument is to say that the requirement in Rule 9.1 for the claim, defined term, to be, quotes, under a protected contract of insurance, should be read as only requiring a valid claim made in connection with a civil liability under a protected contract of insurance. And accordingly, they say the definition of protected claim covers claims in connection with protected contract liabilities, including claims for statutory interest and court costs. Now, again, the argument turns on the definition and the meaning of the words in respect of in the definition of claim. And we, as you know, submit that those words mean or should be read as meaning for or for payment of. And our submissions in answer to this alternative ground 2 are as follows. First is obviously this ground only arises if ground 1 fails. If the respondent's argument as to the construction of in respect of in Rule 3.21 is wrong, it's very difficult to see how this argument about the meaning of the very same words in the definition of claim can be right. Second, Rules 17.1 and 20.2 are fatal to this argument. And I re-emphasise that on this alternative argument, the respondent's claims for interest and costs are said to be protected claims. The problem for the claimant, the respondents, is that Rule 17.1 provides the limits on the maximum claims payable by the FSCS for protected claims set out in Rule 17.2. 17.2 in turn sets out that the 100% limit for building guarantee policies, but then provides that each case cover should be determined in accordance with 19 and 20. So 17 drives you to 19 and 20. And 20.2 provides mandatorily that FSCS must calculate the liability of a relevant person under a relevant general insurance contract in accordance with the terms of that contract and pay that amount to the claimant. All that is to be paid, therefore, is the amount payable under the terms of the contract. There is no requirement or room for FSCS to pay any amounts that are not payable under the contract, such as statutory interest or court-awarded costs. And that demonstrates that the words in respect of, in the definition of claim, mean for or for payment of. The respondents appear to argue that Rule 20.2 is not exhaustive, but that is inconsistent with the mandatory language of 17.2 and the mandatory language of Rule 20.2. So that argument just in our submission doesn't wash. And we also repeat the point that I made this morning that it would be bizarre if there were this whole category of claims in respect of which the rules are silent as to what needs to be paid and what calculation needs to be performed. It's just not a credible reading of this scheme of rules, we say. There are some further rules which we identify in paragraphs 6.3a to c of our supplementary skeleton. You'll be aware we've filed 2 skeletons. 6.3a to c of our supplementary skeleton, which further support our construction. But again, I don't propose to take you to those rules now. We rely on what we say there, but I've nothing further to add. And finally, we respectfully invite the court to return to the definition of protected claim, namely a claim under a protected contract of insurance. That is the definition in the rules of protected claim. the respondent's argument seeks to rework that definition so as to obscure the requirement that the claim needs to be under the contract. We say that their reading subverts the natural reading of Rule 9.1 and indeed the scheme of the rules more generally. That's all I was proposing to say in relation to ground 2. Ground 3 I can take more shortly still. The respondent's final alternative argument is that claims under a protected contract of insurance is to be construed as meaning claims arising out of the contract of insurance. If you look at their skeleton, you will see that that is the way in which they try to put this. This argument is, with respect, hopeless. Rule 9.1 requires the claim to be under the contract of insurance. The natural meaning of under is not arising out of. Second, the provisions of Rule 20, once again, setting out how to calculate the compensation to be paid, requires the liability under the contract to be calculated and that amount to be paid to the claimant. And third, Rule 9.8, which I don't think you have been taken to so far.
So your reference just now was to 20.2 again, was it?
Yes, it was, yes.
Thank you.
Finally, if we go to Rule 9.8,
9.8.
yes, which is at page 208, thereabouts, tab 15. This rule provides the FSCS must treat liabilities of a relevant person or, where applicable, successor, which is in default, in respect of the following items, as giving rise to claims under a protected contract of insurance. And if we just take the third one by way of example, the unexpired portion of any premium in relation to relevant general insurance contracts which are not reinsurance contracts. So pausing there, this provision would not be necessary if under encompassed arising out of, because a claim for the unexpired portion of a premium would inevitably be a claim arising out of the contract. And what 9.8 shows is an awareness on the part of the draftsperson that some claims against an insurer will not be claims under the policy, and an intention only to extend the scheme to certain of those claims through what is in effect this deeming provision. One last point, which just to clarify something that I said this morning, the DISP rules, which I referred to this morning, we understand that they were made by the FCA under sections 226, 227 and 229 of FSMA.
226, 227,
29.
229, thank you.
FSMA, not 213.
Yeah.
But the comp rules were made under 213. And they still form part of the FCA.
The comp rules are referred to in that earlier case that is discussed, I think.
Yes, the DISP and the CAS rules are all part of the FCA handbook. As is comp.
The relevant CAS rules in Lehman Brothers were made pursuant to directives, weren't they? I think.
Might be right.
Don't mind, we can.
So unless I can assist you further, those are my submissions.
Thank you very much. Well, we'll take time to consider our judgments. We can't promise when you'll get them, but when you do get them, they'll be handed down in the usual way. Let's say you'll get them in draft. They're subject to embargo. You'll all know how seriously the embargo is taken and the sanctions that can be imposed if it's breached. That's for the purposes of typographical and administrative corrections, not re-arguing the case. And we'll invite written submissions on consequential matters at the same time. So it just leaves me to thank you both, but equally perhaps more so those behind you, for all that's gone into putting forward very interesting